Welcome to the Supreme Court Podcast. All opinions expressed in this podcast do not reflect the views of the Supreme Court. For clarity, the text of the decision prevails.
In 2016, Lazada E-Services Incorporated hired Rogelio Garalde Mendaros and 6 other motorcycle riders under individual contracts titled Independent Contractor Agreement for a fixed term of 1 year. Using their own motorcycles, the riders were tasked to pick up items sold through the Lazada platform from sellers and deliver the same to Lazada's warehouse. Each were paid 1,200 pesos a day for their services. Subsequently, however, Lazada terminated their services as they were removed from their usual routes and were no longer given any schedules even before the term ended. Similarly, in a different field, petitioners Escauriaga and 4 others were engaged as fitness trainers by Fitness First Philippines Incorporated on different dates between 2003 and 2012. As fitness trainers, they sold and marketed the physical training programs and packages of Fitness First, as well as conducted actual training sessions for their clients. They were paid fixed monthly salaries, 13th month pay, and commissions. However, when they were later reclassified as freelance trainers, they were only paid their salaries, but not the other benefits. Believing they were regular employees, the trainers did not comply when Fitness First in March 2017 required them to register their alleged freelance business as required by the Bureau of Internal Revenue guidelines and policies for the monitoring of service fees of professionals. The riders of Lazada and the fitness trainers of Fitness First filed a complaint before the National Labor Relations Commission and subsequently elevated the same to the Court of Appeals. Both the NLRC and CA held there was no employer-employee relationship between the parties. This prompted them to bring their case to the Supreme Court. What defines an employer-employee relationship? What is a regular employee? And under what circumstances is a dismissal considered illegal? Hi, I'm Attorney Mike Navallo, Supreme Court Chief Communications Officer. It's the 25th of April 2025, and today we talk about labor disputes with focus on the definition of employer-employee relationship and the criteria that classify an individual as a regular employee within the context of the cases of Rogelio Garalde Mendaros et al. Versus Lazada E-Services Phil, Inc., GR number 257821, decided on August 19, 2024, penned by Supreme Court Associate Justice Henri Jean-Paul Inting, and the case of Rico B. Escauriaga et al. Versus Fitness First, Inc. and Liberty Cruz, GR number 266552, decided on January 22, 2024, penned by Supreme Court Associate Justice Atty. Lazaro-Javier. And joining us to talk about these cases is Undersecretary Filemon Javier, who heads the Legal and Legislative Affairs Strand of the Department of Education and was most recently a Labor Law and Social Legislation Bar Examiner for the 2024 Bar Examinations. Hi, Usec Javier. Thanks for joining us and welcome to the Supreme Court Podcast.
Hello, Attorney Mike. Hello, everyone. I'm glad to be here.
All right, Usec Javier, let's talk about this concept of a regular employee. What makes a person a regular employee? And people would usually ask, is that the same as being a permanent employee?
We can categorize an individual as a regular employee if that individual is an employee in the first place. You can imagine that the question about regular employment will only be relevant if we are sure that that person is an employee in the first place. Now let's assume that that person is an employee. Then that question is to be asked. What kind of employee is that person holding? The test would be if the employee is performing functions that are usually necessary or desirable to the usual trade or business of the employer. In other words, there must be a reasonable connection between the activity of the employee and of the business of the employer. If that activity is usually necessary or desirable, then as a rule, that individual is a regular employee. The concept of permanent employment is a laymanized term for a regular employee. If you look at the statutes and even jurisprudence, there's no classification of employment as permanent employment. It's just a laymanized term of regular employment. So I can say that they're the same, Attorney Mike.
Right. And as opposed to a casual employee who is is not a regular employee? How do we distinguish, Usec?
Yeah, so a casual employee is the reverse, in a sense, of a regular employee, because a casual employee is merely performing incidental function. In other words,
Mm-hmm.
even if that employee is not performing that function, the company would still survive. The company would still exist. Versus a regular employee who is performing the activities that are usually necessary or desirable to the usual trade or business of the employer.
And you mentioned a while ago that we need to determine first whether a person is an employee. I understand there's a fourfold test in determining an employee-employee relationship. Can you discuss to us briefly what are the criteria for determining the presence of an employee-employee relationship?
So in determining the status of an individual, whether he or she is an employee, the Supreme Court, because this test is a jurisprudential creation, so the Supreme Court almost always use the fourfold test. The fourfold
Mm-hmm.
test, as the name denotes, has four tests. The first one is the power to engage or to select the individual. The
Mm-hmm.
second one is the power to pay the wages. The third
Mm-hmm.
would be the power to terminate or to discipline the individual. And the fourth, which is the most important test, is the power to control not only the end result, but also the means and method upon which the individual performs the work.
And there's another concept, Yusek, the concept of an independent contractor. How do we distinguish this from earlier we discussed a regular employee, then we have a casual employee, but now you have an independent contractor. What are the similarities and what are the differences between these statuses?
In terms of similarities, both the independent contractor and the employee of a company work for the company. They perform services for the business of the company. But the difference would be if the individual is an independent contractor, the company does not control the means and method upon which the individual performs the work. In other words,
Mm-hmm.
the independent contractor has full and sole discretion on how to go about the service, on how to perform the work. Because if
Mm.
the individual is an employee, and as mentioned a while ago, the most important test is the control test, it is the employer which controls the means and method upon which the individual performs the work. In other words, it is the employer which tells the individual how he or she should perform the services.
Mm-hmm. Unlike an independent contractor who has some sort of leeway how to go about it.
Yes, the independent contractor has complete control how to do the service. The principal
Mm-mm.
is only interested as to the end result. No, as long as the independent contractor produces the result, then that's it. No matter how the independent contractor will perform the service, it's up to the independent contractor.
Mm-mm. So, in the case of an independent contractor, we won't apply the fourfold test because the control aspect of the fourfold test is missing. Is that right, Yusek Javier?
That's correct. So in a sense, if you test the independent contractor versus the vis-a-vis the fourfold test, the independent contracting arrangement will not pass that fourfold test.
Right.
It may
Mm-hmm.
pass the first three because an independent contractor is also selected. An independent
Mm-hmm.
contractor is also paid,
Mm-hmm.
which is called service fees. And of course, the principal can also terminate the independent contractor agreement. But the fourth
Mm-hmm.
test will fail because in an independent contracting arrangement, the principal is only interested or has control over the end result. But in an employment relationship, the employer has control on how to perform the work itself.
In cases of dispute, Yusek Javier, if you don't know what exactly is the status of the employee, whether as an independent contractor or as a regular employee, who has the burden to prove this?
If the question is the status of employment, it is the employer which
Mm-hmm.
has the burden of proving the status of employment. So if there's a case, it's the employer who has to prove that and normally which will be the case, that the individual is an independent contractor. If the employer fails to do so, then most likely the default will kick in, and the default is regular employment, because regular employment is a situation wherein the individual is most protected in.
Mm-mm. And what are the implications, Yusik Javier, for this classification? For example, if a person is determined to be a regular employee, what are the repercussions as opposed to this other person who may be an independent contractor?
Yeah, a lot, Attorney
Mm.
Mike. The categorization will lead to the answer which law governs. No? If the
Mm.
relationship is employment relationship, then the labor code will primarily govern. If the
Mm-mm.
relationship is independent contracting arrangement, then the civil code and the contracts will primarily govern. There is also an implication on jurisdiction. No? If the
Mm.
relationship is employment, so the case should be filed before the National Labor Relations Commission. If the relationship is independent contracting, then the dispute must be resolved by the regular courts. There's also an
Mm-mm.
implication on benefits. If the individual is an employee, of course, the individual will be entitled to the labor standards as provided for in Book 3 of the Labor Code, like overtime pay, holiday pay, night shift differential, among others. And most importantly, if the individual is an employee, then that individual is protected by the security of tenure. In other words, that individual, an employee, may only be terminated when there is just or authorized cause as enumerated in the labor code and upon compliance with the procedural due process. Those are not
Mm-hmm.
present if the individual is a mere independent contractor, because the termination of employment would be dependent on the stipulations of the contract between the principal and the contractor.
Right. So if it's stipulated that at any given time the contract can be terminated right away, then that can be done on the basis of those grounds in the contract. Unlike under the labor code, where you have a notice requirement. Now, in the Mendaros case, in the case of the Lazada riders, Usec, how did the Supreme Court characterize the task of Lazada riders? Can they be considered independent contractors or regular employees? Because the argument is that, oh no, they operate their own motorcycles. They determine how to go about delivering the services. Is that a valid invocation of the independent contractor arrangement?
Well, the Supreme Court said it's not an invalid argument. No, the
Mm-hmm.
Supreme Court found that the individuals in Darar's case are actually regular employees of Lazada, and in fact,
Mm-hmm.
the services that they performed were categorized to be usually necessary or desirable to the usual trade or business of the company, because the Supreme
Mm-hmm.
Court said the delivery of the items would be reasonably connected to the business of Lazada. It's as it is reasonably necessary or desirable to the usual trade or business of the employer. The riders in that case were considered employees because the Supreme Court found that the company control the means and method upon which they perform the work. For example, it was found out that the riders log in their time, no, during arrival,
Mm-hmm.
loading of items, even departures in the store or in the cellar. And in fact, it was the company which give the gadgets to the individuals to be used for in the monitoring. So they were considered not only an employee, they were considered regular employees of Lazada.
Mm-hmm. So it's very clear here that based on the control test, Lazada has control over how they do go about their activities, and the other three factors in the fourfold test are also present: selection, engagement of employee, payment of wages, and power to dismiss.
That's correct. All four must be present, and it was found out that all four are present. They were selected, they were being paid, and in fact, they were terminated. And the control test is the most important. The Supreme Court found that. Also, in the contract of the riders, there is Annex I, wherein the company had the ability to evaluate the performance of the individuals on a monthly and quarterly basis. So the Supreme Court said this kind of provision was also indicative of the employment control.
And you mentioned the contract. That same contract included a statement that there was no employer-employee relationship. So does that statement in the contract carry any weight, Yusek Javier?
Because employment relationship is imbued with public interest,
Mm-hmm.
while stipulations in the contract are important, but they are always tested on what is happening in the real arrangement of the parties. If the real arrangement is employment relationship, the stipulation of no employment relationship will be brushed aside by the courts to protect the individual. So in a sense, those kinds of stipulations would not be valid defense if it is found out that the fourfold test is complied with.
And one finding here of the Supreme Court is that the petitioners from Lazada, the Lazada riders, were found to be regular employees without a fixed term. What's the significance of this finding, without a fixed term?
Well, it only means that their employment will not be terminated after a lapse of a certain period. In other words, there is no term. Their employment will only be terminated if there's a reason as stated in the law that it can be terminated. And those reasons are expressly provided for in the law. They are called just and authorized causes, and only after compliance with strict procedural requirements.
And the court determined in this case that they were, in fact, illegally dismissed. So Lazada did not comply with the grounds for their termination. Can you discuss this to us briefly how this was the case, Usec Javier?
That's correct, because if a company views an individual as an independent contractor, that company almost always will not use the grounds to terminate as provided for in the labor code, because that would be an admission that an individual is an employee. So the independent, quote unquote, independent contractors will be terminated based on what is stipulated in the agreement. And in case the courts later on find out that the individuals are employees, then there's no turning back. Now, those individuals were removed from service not because of just or authorized cost, because in the first place, the company did not treat them as employees. So that is what happened here. They were removed from the services without applying the provisions of the labor code, because the company felt initially that they were independent contractors. And that's why when the Supreme Court looked back at what happened, it's an illegal termination, because the causes for termination were not there, and the procedural due process for terminating an employee was also not complied with.
Usec, in the Mendaros case, there were recent jurisprudence cited by that ponensya. For example, Borromeo and Parsha versus Lazada E-Services Philippines. You have Ditiangkin versus Lazada E-Services, among other cases, where similarly situated riders were also declared to have been illegally dismissed. Can we now say that based on this jurisprudence, if you are similarly situated rider working for Lazada or any other company, that is your status, that you are a regular employee, regardless of what your contract says?
If similarly situated, I think it's safe to say that, Attorney Mike, we follow the concept of stare decisis, which literally means to stand by things decided. It's a legal principle where courts adhere to precedents established in prior cases in deciding similar cases to ensure consistency and predictability in our legal system. So if the facts are similar, I would say the result will be similar as well, Attorney Mike.
What would be a factor that would more or less make it an independent contractor? Like, looking at the case, what would have made it an independent contractor arrangement?
Well, if the individuals are completely free from the control of the employers, for example, they are no longer monitored, the putative employers would only be interested to the end result. They will just know at the end of the day whether the items were delivered or not, regardless of how the riders are able to do it. There's no exclusivity of the agreement. For example, the riders are able to offer their services to other companies or perform other work during the day. Those indications might turn the tide, so to speak. Without control and without economic dependency, the riders may not be considered employees. They may be considered independent contractors.
All right, that's very clear, Usec Javier. Thank you for that explanation. Let's go to the other case, Escauriaga. In the case of fitness trainers who are paid by commission, and there are peculiarities in this case because they used to be paid fixed income and allowances, but there was a change afterwards. Can they be considered regular employees, or are they independent contractors?
Well, in the case of Escauriaga, they were considered employees. In fact, they were considered regular employees because their performance of work upon test in the fourfold test were found to be controlled by the company. and that the services that they performed are usually necessary or desirable to the usual trade or business of the company. So if you
Mm-mm.
look at the fourfold test, which the Supreme Court also used in this case, they were considered employees and then later on regular employees of Fitness First.
Aside from the fourfold test, USEC, the Supreme Court also employed the economic dependence test. What is this test, and how did the court apply it in the case of the fitness trainers?
The economic dependency test is a confirming test. In other words,
Mhm.
if the question is about the presence of employment relationship, most of the time the fourfold test would be sufficient to answer that question. But if there are
Mhm.
instances wherein there's a genuine confusion as to the relationship, or if we want to confirm the status of the individual, we use the economic dependency test to confirm or to check whether the individual is really an employee or not. The economic dependency test is the question to be asked is whether the individual is supposed
Mhm.
to be economically dependent upon the putative employer uh, for their sustenance in the continued employment in this line of business. So if the individual is dependent on the putative employer on how to survive or their livelihood, the relationship of employment is confirmed. So in other words,
Mm.
when the courts look at the situation, they use the two tests, the control test and the economic dependency test. That's why it's a two-tiered test, because the second test is a confirming test.
Right. So you apply first the fourfold test before the economic dependency test.
Still, that's important. In other words, the economic dependency test will not supplant the control test. We use the economic dependency test only to check, only to confirm that employment relationship is present or not.
But it's also possible that this test won't be employed at all when the fourfold test is already very clear that this is a regular employee.
Yes, I would suppose 90, just give it an arbitrary number. 90% of the time the fourfold test would be sufficient to determine employment relationship. It's very seldom that we use economic dependency test. It's only in instances where there's a genuine confusion as to the
Mhm.
status of the individual. For example, we have the case of Francisco versus NLRC. In the case
Mhm.
of Angeline Francisco, she held several positions in the company. Some are undisputably employment position, some are for corporate officer position. So there's a confusion. In the cases of the riders in Lazada, there are some items which are there's a semblance of independent contracting arrangement. For example, the riders are using their own motorcycles in performing the service. So
Mhm.
probably that's the reason why there was a need for us to confirm, to truly check whether the relationship is employment or not.
Right. Having ruled USEC that the Lazada riders and Fitness First trainers were regular employees, what additional entitlements, aside from reinstatement, were they entitled to? If you're a regular employee, what do you get?
So if you are a regular employee, you get back wages normally. No, when
Mm-mm.
there's this, you get the back wages. In other words, you would have been entitled to the wages that you would have earned during the pendency of the case. You will also be entitled to employee benefits such as 13-month pay. The individuals will also be entitled to attorney's fees because that's part of what the labor code provides. No, in certain
Mhm.
instances, you may be entitled to damages if there's bad faith on your termination. So moral and exemplary
Mm-mm.
damages would be awarded provided that there's bad faith or malice on the termination of employment.
All right, that's very clear, Yusek. Finally, just to close our discussion, what do we need to keep in mind, especially those listening who may not be very familiar with the law, to determine our status, whether we are a regular employee or not, and what we are entitled to uh, as an employee of the company?
I think ultimately the question to be asked is whether the putative employer controls your work. If the
Mm-hmm.
putative employer controls your work, then you are a regular, well, you are an employee of the company. Once the individual is considered an employee, then all the benefits, rights, and protections under the labor code will kick in and would be applicable. But if the company is only interested in the end result. So for example, you engage a contractor to build your house. You don't tell that contractor how to build the house, just that you want the final look of the house to be as what is in the plan, then that individual is not an employee. That individual is an independent contractor because the company or the principal is only interested in the end result. And therefore, the
Mm.
rights of that individual will not be based on labor code. The rights and the benefits or the privileges of that individual will be based on the contract between the parties.
All right. Thank you very much, Usec Javier, for joining us today. Very enlightening discussion.
Thank you. It's my privilege to be here, Attorney Mike.
And if you wish to read the full text of the court's decision, you can go to the Supreme Court website and e-library. Just search for Rogelio Garalde Mendaros et al. Versus Lazada E-Services Phil Inc., GR number 257821, and Rico B. Escauriaga et al. Versus Fitness First Philippines Inc. and Liberty Cruz, GR number 266552. Here's Steph Atendido Beltran, Supreme Court Information Officer for this week's Roundup.
From the Supreme Court of the Philippines, here's the latest. The Supreme Court has upheld the right of barangays Trancoville, Outlook Drive, and Military Cutoff in Baguio City to hold bingo games as fundraising projects without needing permits from the Philippine Amusement and Gaming Corporation, or PAGCOR, or any national or local government office or agency. The court en banc through Associate Justice Jose Maidas P. Marquez affirmed the right of the three barangays to hold bingo sa barangay events to raise funds for barangay projects without requiring a permit from PAGCOR. The SC held that under the Constitution, barangays are basic political units with local autonomy. Section 391 of the Local Government Code allows barangays to hold fundraising activities, such as bingo games for local projects, provided they comply with national standards on morals, health, and safety. The SC also emphasized the power of barangays to generate local revenue. Supreme Court en banc has ordered retired Court of Appeals Associate Justice Isaias P. Dikdikan to answer within 10 days the gross misconduct charges for his alleged involvement in the murder of attorney Joey Luis B. Wee in 2020 in Cebu City. Acting on the memorandum of Court Administrator Raul B. Villanueva, dated March 24, 2025, the SC initiated the administrative proceedings against Justice Dikdikan following his alleged involvement in the case, which was endorsed by the National Bureau of Investigation, or NBI, to the Cebu City Prosecution Office and or the Office of the Prosecutor General. Wee was shot and killed on November 23, 2020 at the ground floor of the building where his law office was located in Cebu. The Supreme Court warns the public against fake orders, notices, issuances, and advisories falsely attributed to the Supreme Court and other courts and offices in the judiciary. The public is also warned against individuals fraudulently claiming to be court employees. In another case, the Supreme Court has ruled that unauthorized structures on public land, including videoke machines, sari-sari stores, billiard tables, carinderias, and other businesses on beaches, may be demolished for being public nuisances. In a decision written by Associate Justice Amici Lazaro-Javier, the SC Second Division upheld the order to demolish various illegal structures along Matabongkay Beach in Lian, Batangas. The SC found that the structures were built on public foreshore land without the required lease agreement from the Department of Environment and Natural Resources, or DENR. DENR Administrative Order Number 2004-24, in relation to the Public Land Act, or Commonwealth Act Number 141, states that foreshore lands may be disposed of only through a lease agreement with the DENR. SC Associate Justice Mario V. Lopez led the flag-raising ceremony on April 21, 2025 at the SC compound in Baguio City, his last summer session. Joining him were Chief Justice Alexander G. Hismundo, Senior Associate Justice Marvic M. V. F. Leonen, and Associate Justices Ramon Paul L. Hernando, Amici Lazaro-Javier, Henri John Paul B. Inting, Ricardo R. Rosario, Josep Y. Lopez, and Japar B. de Maampao. In a short message, Justice Lopez reflected on his career in public service spanning over 40 years. Justice Lopez was appointed as the 185th Associate Justice of the Supreme Court on December 5, 2019, and is set to mandatorily retire on June 4, 2025. The Office of the 2025 Sharia Bar Chairperson, Associate Justice Antonio Tico Jr., has issued a notice to the 2025 Sharia Special Bar Examinations, or SSBE examinees, on the modality of the 2025 SSBE and extension of deadline to install Exemplify. The deadline to install Exemplify has been extended until May 3, 2025, and examinees must complete the mandatory third sample examination on or before May 5, 2025. You are now up to date with the Philippines Supreme Court. I am Tiffany Beltran, Supreme Court Information Officer.
And that's our podcast this week. Join us again next time for a detailed discussion of select cases decided by the Supreme Court. I'm Attorney Mike Navallo, your Supreme Court Chief Communications Officer. You can catch this podcast on the Supreme Court Public Information Office's accounts on X, Facebook, Instagram, Threads, YouTube, and Spotify. You can also catch previous editions on our website and on Spotify. This podcast episode was produced by the Supreme Court Public Information Office with Attorney Karen Martinez, Jay Rempilio, and May Sibal as researchers, and Lawrence Olaño as sound editor. Tyke Flores and Jerome Batamalake as web editors.